Welcome to the Judicial Committee of the Privy Council. Today we are hearing an appeal from the Court of Appeal for Bahamas in the case of RAV Bahamas Ltd and another, and Therapy Beach Club Incorporated. The appeal concerns an award in a commercial arbitration following on from RAV's unlawful eviction of Therapy from property which it had leased. The appeal focuses on the power of the court to hear challenges of an arbitrator's award under Section 90 of the Bahamian Arbitration Act 1999 on the ground of serious irregularity. Today, the appellants, RAV, are represented by Mr. Vernon Flynn QC and Stuart Cribb, and the respondents, Therapy, by Ms. Crystal Roll QC and Wallace Roll. Before inviting Mr. Flynn to begin his submissions, I will introduce the panel of the board. I am Lord Hodge, and sitting with me today is Lord Hamlin.
Good morning.
Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
And Lord Stevens.
Good morning.
Mr. Flynn, I now invite you to present your appeal.
Thank you, my lord. There's one main legal issue of principle on this appeal, and is the issue which is dealt with in the minority judgment of the Court of Appeal. In short, it is whether, in order to uphold a challenge to an arbitration award for serious irregularity under Section 90 of the Arbitration Act of the Bahamas, firstly, does there have to be a separate and express allegation or pleading of substantial injustice by the claimant? And second, does the court separately and expressly have to consider whether the irregularity complained of has caused or will cause substantial injustice, and to make an express and separate finding to that effect? Now, that issue is, of course, an issue of the law of the Bahamas, arising under the Arbitration Act of the Bahamas. However, Section 90 of that Act is materially identical to Section 68 of the English Act, which will be more familiar to the panel. Mr. Justice Winder and the Court of Appeal all decided this case based on English authorities, and on this appeal, both parties have made their submissions on that basis as well. So the panel can approach this appeal on the assumption that the law of the Bahamas is the same as English law. And I'd like to begin, if I may, by outlining the appellant's case for your lordships before I get into the detail. The appellants do not contend that its serious irregularity complaints do not have to satisfy the requirement of substantial injustice. That requirement is embedded in the language of Section 90. The issue on this appeal is whether, in order to satisfy the substantial injustice requirement, there had to be a separate and express allegation and a separate and express finding to that effect. The majority of the Court of Appeal answered that question in the affirmative. They said there did have to be a separate and express allegation and finding. In our submission, that was wrong in law and wrong in principle. If, as a matter of substance and on a fair reading of the judgment, substantial injustice has been alleged and found, the requirement has been satisfied. It is not necessary to spell out the obvious. And it is particularly obvious where, as in this case, all three members of the Court of Appeal considered that the serious irregularity would cause substantial injustice. And that's apparent from paragraph 151 of the judgment of the Court of Appeal, which I shall come back to. We submit it's certainly not fatal to a claim for serious irregularity if there's been no separate and express statement that the serious irregularity would cause substantial injustice. Where the allegation is a failure to deal with an important issue, it is not necessary to state the obvious. And we submit that any other answer would introduce inappropriate, unnecessary formalism into arbitration law. And in this case, it would heap injustice upon injustice, particularly in a case such as this, where it's not suggested that the test of substantial injustice was not met. So that is the key issue on this appeal, and I shall seek to make that good in the course of my submissions. But before I do that, I'd like to give the panel a nutshell summary of the key facts to put the key issues in the appeal in context. As the panel knows, the underlying claim relates to a lease agreement dated the 31st of December 2011. The respondent leased premises from the appellants to operate a beach club and restaurant. In 2017, the respondent brought various claims under the lease agreement, including claims in contract and tort, in an ad hoc arbitration seated in the Bahamas. In essence, the respondent's claim was for wrongful eviction from the Sakara Beach Club in the Bimini World Resort. The respondent claimed loss of profits for 6 years, and that included an initial 3-year term of the lease, but it also included a 3-year renewal period based on an alleged option to renew the lease. Now, in the arbitration, the appellants disputed the claim for the renewal period. It disputed that the renewal option was enforceable, and it disputed that it had in fact been exercised. The arbitrator failed to deal with those issues. The respondent doesn't accept that, but as I will go on to show, that is wrong. And those issues are at the heart of the appellant's first ground of challenge to the award. Now, in writing, we have rather inelegantly called that the paragraphs 5 to 8 ground. And in that respect, the claim was made only for the Sakara Beach Club, but also for a separate restaurant called the Atlantic Seafood Restaurant. Now, the respondent said that the Atlantic Seafood and Sakara Beach Club were both covered by the lease. And on that basis, it presented one single global claim for loss of profits. Now, in the arbitration, both parties approached the question of quantum on that global basis. And at no point did the respondent seek to break down the damages claimed between the two sites or to disaggregate the damages in the language used in the proceedings below, or separate them out in any way. And those issues are at the heart of the appellant's second ground of challenge to the award, and we've called that the paragraph 10 ground. Now, the award was rendered on the 22nd of August 2017. The arbitrator accepted that the respondent had been wrongfully evicted from the Sakara Beach Club, and that finding is not challenged on this appeal. However, the claim that the lease also covered Atlantic Seafood was not accepted, and so that part of the claim failed. Loss of profits were awarded only in respect of the wrongful eviction for the Sakara Beach Club, and not the Atlantic Seafood Restaurant. The arbitrator awarded total damages of $9,670,000, which comprised special damages of $370,000, general damages for consequential loss of $6.8 million, and exemplary damages of $2.5 million, with interest at 5% from the 18th of July 2013. Now, the lease contained an estimate of the maximum loss of profits from non-operation of $7,500 per month. And that is a factor mentioned in the subsequent judgments, and in particular in the minority judgment in the Court of Appeal. Now, there are two key points arising from the calculation of the loss of profits. Firstly, the respondent was awarded loss of profits for a period of 6 years, which was obviously inclusive of the 3-year renewal period. Now, however, nowhere in the award did the arbitrator deal with the prior issue as to whether the respondent was entitled to damages in respect of a 3-year renewal period. The arbitrator didn't deal with the new renewal option's enforceability and didn't deal whether it was in fact exercised. The arbitrator made certain adjustments to the loss of profits figure claimed by the respondent. The arbitrator discounted the claim by 1/3 to reflect the failure of the Atlantic Seafood claim, and took off another 15% because the respondent's quantum expert had not supported his report with documents. However, the arbitrator never gave the parties the opportunity to make representations on those deductions, and they came unheralded in the award because the case had been presented on an all or nothing basis. Now, the appellants challenged the award in the High Court of the Bahamas under Section 90 on both of those points. On the paragraphs 5 to 8 ground, it complained that the arbitrator had failed to deal with issues put to the arbitrator. And on the paragraph 10 ground, it said the arbitrator had failed to give a fair opportunity to address the adjustments. And at first instance, Justice Winder upheld the serious irregularity challenge. The respondent appealed to the Court of Appeal, and the majority allowed that appeal. On the main issue, it held that Section 90 required the appellant to make an express allegation that the irregularities complained of had caused or were likely to cause substantial injustice, and to support that allegation with evidence, and that it had not done so. And likewise, It held that Section 90 required Justice Winder to do a separate investigation into substantial injustice, and he also failed to do that. Now, Sir Michael Barnett, the Justice of Appeal, who is now the President of the Court of Appeal, dissented. He held, in essence, that there are some irregularities which by their very nature cause substantial injustice. He held that the arbitrator's failure to deal with whether the respondent was entitled to damages in respect of the renewal period was exactly such a case. And that is how the main issue of principle arises on this appeal. Now, on that key question, we submit that Sir Michael Barnett was right and the majority was wrong. Some irregularities necessarily involve substantial injustice. And the paragraphs 5 to 8 ground was just such an issue. Half of the damages awarded the respondent turned on whether it could claim for the 3-year renewal period. And we understand it to be common ground that there are some serious irregularities which by their nature will cause substantial injustice. But we say it's particularly the case here where there is a failure to deal with a critical issue. And the same is true in respect of the paragraph 10 ground. A substantial part of the award turned on the arbitrator's disaggregation exercise. And we submit that the outcome might realistically have been different if the appellant had been given a chance to address it. And so the requirement of substantial injustice was satisfied on both grounds, even if there wasn't a separate and express inquiry. Now, even if the majority were right, and there is a requirement that there be a separate and express allegation and a separate and express finding of substantial injustice, we submit that those requirements are satisfied in this case. On a fair reading of the appellant's notice of motion skeleton, substantial injustice was in fact alleged on both grounds. And on a fair reading of Justice Winder's judgment, he considered and accepted those submissions. We do accept that the words substantial injustice were not used. It would have obviously been helpful if they had been, but there's no magic in the word substantial injustice. And the respondent rightly accepted in its submissions in the Court of Appeal below that that was the case. To insist that those exact words must be used in all cases would be unduly formalistic. What matters is the substance and the analysis, and on that basis the requirements of serious irregularity were satisfied. So in our submission on either basis, the decision of Justice Winder ought to have stood, and the majority was wrong to overturn it. Now, in relation to other errors in the court below, our second point is that in addition to its conclusion on the main substantial injustice aspect, the majority also held that neither of the appellant's complaints involved any irregularity within the meaning of Section 90. And they said that for 5 reasons. They said, firstly, the complaint had not been advanced as an alleged failure to deal with an issue, but only as an excess of power. Secondly, that the complaint was not an issue because it wasn't spelt out in the pleadings. Thirdly, that the issue was not put to the tribunal. Fourthly, the issue was not one which the arbitrator had to deal with specifically, was merely an argument or a submission. And sixth, the appellant's real complaint was the arbitrator got it wrong. So it was more properly a point of law for appeal. Now, we submit that the majority were wrong on each of those 5 points. Firstly, you have to read paragraphs 5 to 8 of the notice of motion as a whole. They do make a number of complaints about the period for which the arbitrator awarded damages, and one of those complaints was expressly the failure to deal with issues. Secondly, point doesn't have to feature in the pleadings to constitute an issue. What matters is whether the point was fundamental or sufficiently critical to the decision. And in this case, it obviously was, because damages couldn't properly have been awarded for 6 years without a determination of the renewal period issue. Thirdly, the issue was put to the arbitrator, especially in the appellant's oral closing submissions, and I'll show you that later. Fourthly, because the point was an issue and put to the tribunal, the arbitrator was required to deal with it, and it wasn't dealt with. Now, a failure to deal with an issue is a classic irregularity complaint. It's one of those types of serious irregularity which do succeed on a challenge. It's the failure to deal with the issue at all which is the complaint. It is not simply a case that the arbitrator got the decision wrong. or it fell outside the permissible ambit of a challenge to an arbitral award. So far as the paragraph 10 ground is concerned, the majority also held there was no serious irregularity there, or indeed no irregularity at all, for two key reasons. Firstly, the appellant had the opportunity to make submissions on damages, and they said, in essence, the complaint was in truth a point of law for appeal. Now, we submit that the majority was wrong on both of those points as well. The appellant didn't have an opportunity to address the deductions made by the arbitrator because a hybrid case was not previously in the arena. Both parties had addressed quantum on a global basis. No alternative case was advanced by the respondent, and the arbitrator's disaggregation of the respondent's global claim came unheralded in the award. And on the second point, as it being an error of law, it's the same as the error in relation to paragraphs 5 to 8. A failure to give the parties an opportunity to address an issue is again a classic irregularity complaint. It's not simply a challenge to the result on the basis that it was wrongly decided. It is a serious irregularity as to the procedure adopted by the arbitrator. And we submit for those reasons the majority were wrong to overturn Justice Winder. Thirdly, I just want to identify the relief that the appellants seek on this appeal. And for that, I do want to take you to the judgment of Justice Winder. It is at page 177 of the bundle, if you're using the electronic bundle, and it's paragraph 50.
Mr. Flake, you can assume that we are all using the electronic bundle. We do not have paper copies.
Excellent. I think that will make life a lot easier. If you turn over the page, please, to 178, and could I ask you to read paragraphs 51, 52, and 54. So your lordships will see that those paragraphs were overturned by the decision of the Court of Appeal, and what we are asking is for those paragraphs 51, 52, and 54 to be reinstated. And in short, we ask for the award of damages to be remitted back. So the issue as to whether damages can be recovered for the renewal period can be dealt with by the arbitrator, and that there is a fair opportunity to address the disaggregation of the respondent's loss of profit claims. Finally, on the introductory matters, there is one other issue which the court might be required to consider on this appeal. The respondent. Sorry, my Lord Hammond.
So what about the point in paragraph 50, subparagraph 3, which is a slightly different point? Does that feature in your appeal? There's no separation out between contract claims and other claims.
Yes, that's part of our paragraph 10, which is that in other words, the paragraph 10 point is that it's the entirety it was only presented to the tribunal as a global claim. If there is to be an alternative claim, anything other than a global claim, then the arbitrator needs to consider that in the light of
that's your paragraph 2 point, 52 point.
Yes.
Where you refer to the disaggregation and the no documents point, but this is a rather separate point. I didn't understand that feature separately in your appeal.
No, my lord, that's right. It is only
it's 1 and 2.
Yes.
All right.
Yes. Yes, it's only paragraphs 51, 52, and 54 we're asking to be restored.
Well, I wonder if some of the directions which are given actually relate to that paragraph 50, subparagraph 3. Paragraph 53. You can come back to this, but I think it needs to be clear.
I can, and my lord, to be fair, I'm not sure we got permission to appeal on paragraph 50, subparagraph 3.
No.
So it would only be what falls into from the restoration of 51, 52, and 54. So we would ask for those paragraphs to be restored and to be remitted back on those paragraphs. I cannot, I don't think, fairly say that we would also ask for 50, subparagraph 3 to be included. My lord, there's one other technical issue. I'm not sure if it is really being advanced, and that is yes, that is that the respondent contends the Court of Appeal didn't have jurisdiction to grant the appellant's permission to appeal.
Before you go there, Mr. Flynn, I think Lord Stevens would like to ask a question.
Oh, I'm so sorry, Lord Stevens.
No, not at all, Mr. Flynn. Thank you very much indeed. I was just wondering why your client didn't avail of the opportunity in front of the arbitrator of asking the simple question as to what the position would be if the Atlantic seafood restaurant was taken out of the equation.
Yes.
So when you were saying that it's unfair that you didn't have the opportunity of advancing this point, you had all
Yes.
why didn't you have the opportunity? Why didn't you seize the opportunity in front of the arbitrator?
The answer, my lord, is this, and on that we submit that our paragraph 10 point is the application of some fairly well-established principles, which most recently have been dealt with in the Kazakhstan case, which in our submission establishes that where a case before the arbitrator is brought on a single global basis, in other words, both parties are proceeding that on the basis that it's all or nothing, there is no obligation or requirement for either party to address an alternative claim that isn't being advanced. Because the difficulty with that putting in an alternative claim is, unless it is actually advanced, one would simply be guessing as to what that claim might be. And in circumstances where that is not advanced, as happened actually, I'm going to show you the Kazakhstan, in our submission, on all fours. In those circumstances, unless an alternative case is advanced, there isn't an opportunity to deal with that alternative case. And what the arbitrator should do in those circumstances is to go back to the parties or produce only a partial award on the basis of the findings that the arbitrator wants to make, which are not what the parties have asked for, and then give the parties an opportunity to address that. What isn't correct in my submission is that either party should have to address any number of possible alternatives which weren't in fact advanced. So what happened here is that it was simply all or nothing, and in those circumstances it was a serious irregularity to deal with quantum on an alternative basis that wasn't advanced. And in those circumstances, we submit there is no fair or real opportunity to address the alternative case, because the first time one sees it is in the award itself. I will show you Kazakhstan on that, because I can totally see where your lordship is coming from. But in a case where it's all or nothing and there's no alternative case, it is rather different to an ordinary case where any number of possibilities are canvassed before the arbitrator as alternatives, and then one does have to address those alternatives. Well, here it's different because it was all or nothing.
Well, we'll have to look at the Kazakhstan case. But
yes.
Here, this was an alternative that was being advanced by your clients, namely that the Atlantic seafood restaurant wasn't part of this lease.
Well, except it was but we was, in a sense, it was all or nothing. So we were saying it was nothing. They were saying it was everything. There was no hybrid case advanced. There was no, if it's only the restaurant, then X, and if it's only the building, then Y. And in my submission, that does make a difference in terms of approach. I'll come. It's probably better, my lord. I totally have this point on board. If I come back to the case, and then you can see where the principles are.
Thank you very much. And thank you.
Not at all. I totally accept the point, and I will have to meet that. But Kazakhstan is probably the best place to find out. Lord Leggett.
Making submissions on this point isn't going to go very far, is it? Because as I understand it, there just isn't any evidence as to what the position would have been with only the beach club. So it really needs to be more evidence on the point.
Yes, it did. It absolutely did, my lord. And you can see from the approach which the arbitrator took, which was a sort of frankly, finger in the air approach, which Sir Michael Barnett addressed that and said it was just purely impressionistic. And I think that is a very powerful and fair criticism of the arbitrator, which was in circumstances which the arbitrator found herself, which was that she decided that she didn't want to do an all or nothing approach. It wasn't appropriate to do the exercise that she did in fact do, which was do her best on the, putting it at its best, doing the best on the material that was available, because there wasn't sufficient material. And she wasn't assisted by submissions on the alternative case. And so that's why you get
into a challenge to the correctness of the finding itself.
Except that it would, in order for my submission to be wrong, I think it would be necessary to say that there was some obligation on my clients to put in evidence on a case that wasn't being advanced. So if it's all or nothing, then obviously the case must address the all or nothing issue. But where there is no case in the alternative, it wasn't incumbent on my client to put in evidence to meet an alternative that wasn't being advanced. And one can see the difficulties that may arise if a different approach is taken, which is that a party then has to guess what the alternatives might be. I mean, as it turned out, this was one of the alternatives. There may be others, maybe many alternatives, but unless they're clearly articulated, it's very difficult to see how or why a party can put in evidence on a point that isn't taken. Exactly the same thing happened in Kazakhstan. It was presented as an all or nothing case. The tribunal in that case, I'll come to it in a moment, but the tribunal in that case reached a hybrid decision, somewhere between all or nothing. And it was found that there was a serious irregularity leading to substantial injustice, because the tribunal should have gone back to the parties before proceeding on an unheralded alternative case. But I think, as I say, I think probably best to deal with that case issue by reference to the case. So you can see that case does deal with the authorities in some detail, and you'll see what happened in that case.
Thank you. You can deal with that when you come to your paragraph 10 submission.
Yeah, yes, I'm very grateful, my lord. So main issue of principle, that is, as I say, where as a matter of substance there is a serious irregularity, should a challenge be rejected and the award upheld because substantial injustice wasn't separately and expressly addressed by the first instance judge hearing the challenge.
I'm sorry to interrupt you, Mr. Flynn. When Lord Stevens asked you a question, you were going to say there was one other technical issue before you went into your submission.
Oh, I'm so sorry. Yes, this you're quite right. Sorry, but this was, as I understand it, the respondent contends that the Court of Appeal did not have jurisdiction to grant the appellant's permission to appeal, and it's said against me the Privy Council should dismiss this appeal for that reason in any event. Now, our case is, as set out at some length in our annex to the written case, that is a hopeless argument and not properly before the court in any event. I wasn't going to say any more about it orally unless the panel wanted to be addressed on it, but we have set out our position at some length in the annex. But that is a procedural issue which is taken against me.
Well, you can address it if necessary once we've heard from the respondent.
I'm very grateful, my lord.
Thank you.
And so in relation to the central issue on the appeal, there are two elements, which is firstly whether the serious irregularity necessarily gives rise to substantial injustice, and if so, whether it's necessary to state the obvious. And secondly, whether on a fair reading of the judgment, it's sufficiently clear that the judge did find that the serious irregularity gave rise to substantial injustice. And as I've said, we submit the majority was wrong in law and principle on that issue. Now, we submit there will inevitably be cases where the procedural irregularity necessarily gives rise to a substantial injustice. And that will particularly be the case where there is a failure to deal with a central or critical issue. And there are obviously many examples one could give, but if the parties have a dispute on the merits as to the construction of a contract and whether it's breached, the respondent may also have a separate defence which would provide it to a complete answer to the claim. Examples might be an exclusion clause, a force majeure provision, a statutory limitation defence. Now, as the panel will appreciate, it is rightly common ground that substantial injustice only requires the applicant to show that it is arguable that the outcome might have been different. If a tribunal failed to consider an issue on which the respondent had a strongly arguable defence, that would give it a complete answer to the claim, and instead find in favour of the claimant, then it's obvious that the irregularity would cause substantial injustice. Now, to require in every case, including a case as obvious as that there must be an express and separate inquiry into substantial injustice, we submit would introduce inappropriate formalism into arbitration law, and as your lordships all know, in arbitration, there's no formal requirement for pleadings. It's commonly done, but it's not like a court, it's not like as it would be in court. And we submit it would obviously give rise to injustice, particularly where, as here, there is no case that the test of substantial injustice has not in fact been met. And in this respect, the respondent made a telling concession in their written submissions. And if I could ask the panel to go to page 1727, please. Paragraph 3.28, where it said, in compliance with its obligation to show that the award might have been different, the applicant might choose to simply assert that the nature of the serious irregularity so found is of a nature that substantial injustice would necessarily follow. So it follows from that in our submission that there can be, the respondent accepts there can be serious irregularities which by their nature cause substantial injustice, and that has to be right. However, having accepted there are some cases where the substantial injustice does speak for itself, they still insist that in such a case, the applicant must, as well as setting out the irregularity, also go on to say, and the substantial injustice speaks for itself. In other words, they are contending that there is a requirement to state the obvious, or to say what goes without saying. If the substantial injustice does speak for itself, to impose an additional formal requirement that the applicant must say so is plainly unnecessary and unduly formalistic. Likewise, if the court finds that the irregularity exists and the substantial injustice is obvious, that should be the end of the matter. And to require the court to go on and say, and I accept that the irregularity complained of has caused substantial injustice because the irregularity is of such a nature that substantial injustice will necessarily follow, is again unduly formalistic, particularly in the arbitration context. And we submit that would be apt to render injustice, not least because it focuses on the form of the judgment rather than the underlying substance. And the respondent accepted below that it's not necessary to use the word substantial injustice. If you would go to page 1614, please, you'll see there an extract from the transcript in the Court of Appeal. I think, my lords, it's important to point out that it's not using the word substantive injustice, you know. They didn't have to do that. Just the analysis, the reference to that fact, listen, had I been allowed to do X, Y, and Z, this likely would have happened, all that. So there's no magic in the word substantial injustice. And the respondent's submission before this court that they must always expressly be used, we submit, is wrong in principle. It's the substance, not the form, that matters. Now, on the authorities, there are 3 points of common ground. Firstly, the parties agree there is a requirement of substantial injustice that arises from the language of section 90. I should just very quickly show the panel the section 90 itself, just to show you that it is exactly the same as section 68 of the English Act. It's at page 1776 of the bundle. And it will be familiar to your lordships because it's materially identical to section 68 of the English Act. In this case, we rely on subsection 92, subsections A and D, and the reference in A to section 44 is a reference to the section equivalent of section 33 of the English Act. That is the obligation to act fairly. And there are two separate aspects that must be satisfied on any section 90 challenge: an irregularity as set out in subsection 2 and substantial injustice. Now, in the respondent's written case, they cite a host of authorities for the proposition that the appellants must show that the irregularities complained of cause substantial injustice. Now, the appellants have never disputed that proposition, and the submissions with respect miss the point. The issue on this appeal is how that requirement must be satisfied. Does every case require a separate and express inquiry? And the cases referred to by the respondent don't address that issue. There is only one case that comes close, and that is the judgment of Mr. Justice Coleman in Bullfract and Boneset Shipping. And I'll come back to that case because there's such heavy reliance on it. The second point is the nature of the substantial injustice requirement. The appellants accept that the test of substantial injustice was designed to filter out unmeritorious technical challenges. So where there is a serious irregularity, but it's essentially a hopeless case. Now, in the light of that, we also accept that we bear the burden to satisfy the requirements of substantial injustice, but that is not an issue on the appeal. And thirdly, the test for substantial injustice is also common ground. Although section 90 is concerned with due process, that's not its exclusive focus. The requirement of substantial injustice means the court must consider the effect of the serious irregularity. If it concludes the outcome would have been no different, there will be no substantial injustice. But we submit it's now well established that where a section 68 applicant can show an arguable case that but for the irregularity, the outcome might have been different, that is sufficient. And we've set out a number of authorities in our case at paragraphs 57 to 63. I don't need to go to them. And not least because that well-established proposition was accepted by the majority in the Court of Appeal. And you can see that from page 209 of the bundle, paragraph 32 of the Court of Appeal's judgment, where they cite from transition feeds, and you'll see the underlined section. The accepted test now seems to be there is substantial injustice if it can be shown the irregularity in the procedure caused the arbitrators to reach a conclusion which, but for the irregularity, they might not have reached as long as the alternative was reasonably argued. So if the outcome might have been different, either because the tribunal has failed to decide an issue or because the applicant has been deprived of the opportunity to address an issue and the applicant has an arguable case, substantial justice is established. So that is the core of the legal background. Now, as I explained earlier, the appellant's submission of principle is that some irregularities will necessarily involve a substantial injustice. In any given arbitration, some issues are so central and important that if the tribunal fails to deal with them or doesn't give a party a fair opportunity to address them, it is inevitable, or at the very least extremely likely, that the outcome... Oh, I'm sorry, my Lord Leggett.
No need to be sorry, Mr. Finney, you were very fast on the uptake, in fact. Maybe this is all too well established, but I'm just wondering whether it's as simple as saying there's a sort of two-stage test like that, and you have to show the outcome might have been different. Might it not matter, as it were, how central the issue is, so that if something is a really critical issue, pretty much unnecessary to show any effect on the outcome, whereas if something is perhaps a bit more peripheral, it might still be satisfy the test if it looks on the face of it to be something that could clearly have been decided in favour of the person raising the point.
Yes.
You see the point I'm making? It might be more an overall assessment rather than sort of breaking it down into two mechanistic parts.
I agree, my lord. I mean, in a sense, that's at the heart of the appeal. Where if the panel is with me, in this case, the issue of the exercise of the option for the renewal period was critical, and in my submission, it plainly was, because it's 3 years of damages that turns on that issue. If that issue hasn't been dealt with, it is at the very least a ready inference that an issue of that kind, a critical issue, which has such obvious consequences, that there will be substantial injustice. In other cases, it might be said, well, the tribunal did fail to deal with an issue, but the issue that it's said to have failed to deal with is so hopeless that the court can decide that it's not a reasonably arguable case. One can see that then the court would say, well, you may have established serious irregularity, but on this case, you don't establish substantial injustice because your case is actually hopeless. I'm sorry, Lord Hamlet.
But that could equally apply to a central issue, couldn't it? Actually, have you not got a threshold of it might affect the outcome in every case? Because if it wouldn't affect the outcome, then that's it.
Yes. The answer is yes. I'm not suggesting that in every case that the mere fact of a failure to deal with an issue gives rise to both serious irregularity and substantial injustice. One does have to analyse it. One can't simply say that just because an issue wasn't dealt with. But there is a question.
The trouble with your injustice necessarily follows. I mean, if there is a hurdle of it might affect the outcome, then you've got to factor that in every case. Actually, you can't just say, well, it necessarily will.
Yes, but it does require an issue. It does require an analysis of the nature of the issue. Can I quickly take you? I was about to take you to the authorities, and I think if you see what is said in the cases, I think this does put the issue in perspective, and I hope will give your lordship some answer to this point, because I was going to say there is a substantial body of authority in favour of my submission. Can I start with we put them in our case, but I'll just show you the extracts from the key authorities.
It's very likely, but it's the necessarily stage that seems to me to go one step further.
Yes. Well, let me. If I take you first to Mr. Justice Toulson's judgment in Ascot Commodities, it's at 1856 of the bundle. At paragraph F, so it's on the right-hand side. And if you could just read from the paragraph beginning, since the whole process of arbitration, and on a fair reading of the award. And just over the page to the first 2 lines at page 285. So you'll see. So
if he had been right in his point of law, then there might have been no serious injustice.
Yeah. So, but what he's saying is the whole process is intended a way of determining points at issue. It's more likely to be a matter of serious irregularity if, on a central matter, a finding is made on a basis which doesn't reflect the case which the party is complaining about. Now, the answer is that does require one to determine whether or not it's a central issue. If it's a peripheral issue, that may be different. Here in my submission, it doesn't arise because this is plainly a critical issue. The renewal period was plainly a critical issue and therefore satisfied the test. And what Mr. Justice Tilson says, it's inherently likely to be a source of serious injustice if those type of irregularities occurred, i.e. a failure to deal with a central issue. Because the whole purpose of arbitration is to deal with central issues. He says in the very nature of things, it's in the very nature of things to be a matter of serious injustice. And one can see that. But I accept that one would have to, there is a prior question, which is it a central issue? Is it a critical issue? Is it a sufficiently important issue? That is, but once one gets to that stage, if the answer to that question is yes, it is a sufficiently important issue, then I would adopt what Mr. Justice Tilson says, that it's very likely in the nature of things to be a matter of serious injustice. Now, then, if you go to 2389, please, you'll see a decision of Mr. Justice Jeremy Cook in Torch Offshore. And you'll see at the bottom of paragraph 21, so at paragraph F, he says, by contrast, I was referred to the decision of Mr. Justice Tilson, Ascot Commodities, where he held that a central point raised by a party which had not been dealt with by a tribunal did amount to a serious irregularity, and because the issue was central, it was likely to give rise to serious injustice. Then could I ask the panel to go to page 2020, please, which is the decision in Checkpoint and Strathclyde Pension Fund. And this is a rare Court of Appeal decision in this area. And as the panel will know, not many Section 68s reach the Court of Appeal because they require leave from the High Court. And Lord Justice Ward said at paragraph 58, at the bottom of the page, 2020, it is the denial of the fair hearing to summarise procedural irregularity which must be shown to have caused a substantial injustice. A technical irregularity may not. The failure to deal with a substantial issue probably will. And then Cameroon Airlines, if we could go to that next, please. Mr. Justice Langley, page 2002. Paragraph. Sorry, Lord Legate.
Been trying to interrupt you for a while, so I'll butt in now, if I may. I mean, might you say that where the issue is central enough, and as it's put inherently likely, the practicality of it is that if the respondent, it's up to the respondent really to say, well, it didn't cause an injustice because there was nothing in the point anyway.
Yes, my lord, I absolutely. That's at the heart of it, really, isn't it? Because what really went on here is a criticism of Justice Winder for not spelling out what we submit as the obvious. He's applying a statutory test. It's set out in the statute. He doesn't mention part of it expressly, but effectively, on a fair reading, he says the statute is satisfied. It's really for the other party to come back and say, well, hold on a moment. The case, it may or may not be serious irregularity, but in any event, there's no substantial injustice because the case is hopeless or for some other reason. But if in the absence of that, in my submission, it's very difficult to criticize the judge where no one is saying that there's no substantial injustice. And that was a point also made in the minority judgment of paragraph 151. In my submission, compelling and powerful, which is the minority judge says, but we all agree, all three members of the Court of Appeal, that there is in fact substantial injustice in this case. Why would it would be quite wrong to set aside the judgment of the first instance judge where there's no case on substantial injustice? Everyone agrees that the test is met. It's just the form of the judgment which is being criticised. So I agree with you, Lord Legate, that it really is incumbent on the party that is saying there's no substantial injustice to spell that out. Otherwise, it's taken effectively as read. And that didn't happen. And indeed, all three members of the Court of Appeal accept that there is substantial injustice in this case. Just wasn't spelt out by the first instance judge.
And it wasn't argued, as I understand, it wasn't argued that that there was nothing in the point about the renewal of the lease, for example, so that no injustice was caused, even though the arbitrator didn't deal with it. That wasn't an argument there.
No, quite.
So
I
there
mean,
was a serious irregularity in the judgment, because that wasn't put in it.
That's right. Rather oddly, in an arbitration case, one is looking at the construction of the judgment of the first instance judge, which in my submission, in a very harsh way, not a way in which you would normally read a judgment or an award, which is to find fault in circumstances where there is no substance to the complaint, in that it's accepted that there is substantial injustice by all three members. It's just the form of the judgment, and indeed a requirement of pleading and spelling out things in a formulaic way that wasn't done. And that's at the heart of the paragraphs 5 to 8 point. I'll try to do this very quickly. Just if one goes next to Mr. Justice Langley in Cameroon Airlines 2002, he says, I think there is likely to be paragraph 113, I think there is likely to be a real risk of substantial injustice in the sense to which I've referred in circumstances where a court concludes that a party has not been given a fair opportunity to address a key issue, as the approach to quantification undoubtedly was, on the basis which was to find favour with the tribunal, and has reasonably conducted its case on that issue on a different and apparently common basis. In this case, I think the risk is manifest. One other case, which I think next case I'll show you is Raytheon, which is a well-known case in this area, page 2268. Mr. Justice Aikenhead conducted a very extensive review of the law in the area. I don't want to take you to that now, but just one passage, paragraph 33H, which is, paragraph 33H, which says at page 2270, where he says, in relation to the requirement for substantial injustice to have arisen, this is to eliminate technical and unmeritorious challenges. It is inherently likely that substantial injustice would have occurred if the tribunal has failed to deal with essential issues. And that's essentially what our submission. It's inherently likely that substantial injustice would have occurred if the tribunal has failed to deal with essential issues. I accept Lord Hamlin's point that one does have to analyse whether it is in fact an essential issue, but once that's established in my submission, that's the test. And then if you look at at page 2280, paragraph 61 of the judgment, at 2280, then you'll see it's where Mr. Justice Aiken said, it follows that the arbitrators overlooked the need to address the issue of claim A4 being a global claim, and therefore to address the fault and responsibility of Z, if any, in relation to the delay, disruption and inefficiencies, which it seems to have been common ground had occurred to a significant extent before the termination. They therefore failed to deal with this issue. It was a very important issue, not least because the consequences of the failure had been that some £126 million had been awarded to Z. It almost goes without saying that necessarily there has been substantial injustice because the arbitrators have not addressed the key issues, and then sets out those key issues. Now, Raytheon's important because it's been cited in 17 other decisions of the High Court, and that statement in 33H has been that it's inherently likely that substantial injustice would have occurred if the tribunal has failed to deal with the essential issues in 3 cases. We don't need to go to them, but I'll just tell you what they are. They're the Celtic Explorer, Halcrow Group and Blackpool Borough Council, and Symbian Power, and we've given you the references in paragraph 72 of our written case to that. So we submit that the authorities recognise that there are some irregularities where substantial injustice is likely in the very nature of things, inherently likely, and almost goes without saying. And they strongly support my principled argument, because in such cases there is no need for distinct formal requirement of a separate and express allegation of substantial injustice, and that those cases haven't been dealt with in my submission in the respondent's written case. Now, your lordships will also have seen from our written case that we also rely on analogy with the approach to applications to remove an arbitrator where there are justifiable doubts about his impartiality. And here, Section 35 of the Bahamas Act also includes a requirement of substantial injustice. And I'll just show you that. It's at page 1771, Section 35, power of court to remove an arbitrator. You'll see a party to arbitral proceedings may, upon notice, the other parties apply to the court to remove an arbitrator on any of the following grounds. A, circumstances exist that give rise to justifiable doubts. And you'll see at the end of the section, and that substantial injustice has been or will be caused to the applicant. Now, Section 35 will be familiar to the panel because it's materially identical to Section 24 of the English Act. And in English law, it is well established that where a party applies to remove an arbitrator, if Section 24(1)(a) is satisfied, i.e. circumstances that give rise to justifiable doubts about the arbitrator's impartiality, substantial injustice will be presumed. In other words, no separate and express inquiry is necessary, and that is notwithstanding that the wording of the statute is the same. And we've set out our cases on this in our written case at paragraph 74 to 80. I'll just show you a couple of them. The leading judgment is ASM Shipping and TTMI, and that involved a Section 68 application to set aside an award on the basis that one of the arbitrators should have recused himself for apparent bias. If you would go, please, to page 1880, it's the judgment of Mr. Justice Morrison in paragraph 39(3), and where he says, in my judgment, if the properly informed independent observer concluded there was a real possibility of bias, then I would regard that as a species of serious irregularity, which has caused substantial injustice to the applicant. I do not accept Mr. Kroll's submission that even if that conclusion was reached, the court must then inquire as to whether substantial injustice has been caused. In my judgment, there could be no more serious or substantial injustice than having a tribunal which was not ex hypothesi impartial, determine parties' rights. And so that's a significant case in my submission because the application was made under Section 68. In other words, the same principles apply in a Section 68 case we submit as in a Section 24 case, or in Bahamian terms, Section 35 principles apply in a Section 90 case. I do want to just show you next a decision in Norbrook Laboratories, partly because it's a decision of Mr. Justice Coleman, and heavy reliance is placed on his judgment in another case. But if you would please go to page 2187, this was an application to remove an arbitrator under Section 24 of the English Arbitration Act because he'd been in direct contact with certain witnesses in the absence of the parties. And the question was whether that failure to conduct proceedings fairly had or would cause substantial injustice. And Mr. Justice Coleman cited ASM Shipping in paragraph 144, and he says at 145, with those observations, I agree entirely. I would also add this. Where there is a sole arbitrator whose impartiality is shown to have been impaired to the effect that a fair-minded and properly informed independent observer would perceive there existed a real possibility of bias in any award already made, substantial injustice will normally be inferred. And where an award is yet to be made, substantial injustice will normally be anticipated. In the former case, the award would normally be set aside under Section 68, and in the latter case, the arbitrator would normally be removed before we could make an award under Section 24. So there's no suggestion by Mr. Justice Coleman that one has to mechanistically apply the criteria and expressly deal with substantial injustice as a separate matter. And two quick points I'd make about those cases. Firstly, the respondent's case hasn't addressed them at all, and they all concern a potentially biased arbitrator. And that is an example of a case where the injustice of a procedural irregularity is obvious and goes without saying. And as a result, there is no need for a separate and express inquiry into substantial injustice. That's even though Section 24 expressly uses those words, and the structure of the statutory provision is in essence the same as Section 90, or in English terms, Section 68. But we submit a biased arbitrator isn't the only case where substantial injustice goes without saying. The same approach should apply in other cases where substantial injustice is equally obvious, such as a failure to deal with a key issue, as in this case. Now, as I said, against that weight of authority, the only case cited by the respondent in its written case, which comes close to addressing the relevant issue, is Bullfract, Cyprus and Boneset. And that was a decision of Mr. Justice Coleman. And if you could turn that up, please, at page 1930.
Before we go there, could I just raise one point with you?
Yes.
The question of Section 24 of the English Arbitration Act arose recently before the UK Supreme Court in Halliburton.
Yes.
And there it was accepted that 24(1)A, justifiable doubts about impartiality, did not have to meet a substantial injustice criterion at all, and that it was only 24(1)D, the refusal or failure properly to conduct proceedings or proceed with reasonable dispatch, that covered that. That required that criterion of substantial injustice being caused. If that's right, we can't really infer very much from cases which deal with an arbitrator's impartiality.
Yes, my lord. I suppose it depends why that concession was made, because the structure of the statute itself is no different. It may be that as a result of the cases, it's accepted that one doesn't have to go on once one establishes the first stage. But the statute itself does contain those words.
But it does, but it's got three grounds, A, B, and C. And this is, I'm looking at 1796. It's got three grounds, A, B, and C, each of which has a semicolon after it. And then it's got a fourth ground, which has the words at the end of it, and that substantial injustice has been or will be caused to the applicant. So the structure of the English Act, certainly, and I think the Bahamian Act is identical, is that there are three self-standing grounds and a fourth ground, which has a substantial injustice criteria.
I see. So that it was accepted that substantial injustice applies only to D.
Yes. Yeah.
Oh.
And you can see why grammatically one could come to that conclusion.
Yes. Yes, I can see that, and you're quite right that it's the same. So I certainly wouldn't want to distinguish the Bahamian Act on that basis. It doesn't. Yes, I mean it doesn't make much
difference to your overall submission.
I don't. No,
it does mean
I don't
that
think
you may not be able to rely on cases relating to impartiality.
No, quite. Well, except this. What I would say, I think, my lord, is this: that the prior cases don't appear to have made that concession or proceeded on that basis. And so I would say, so far as the analysis is concerned, notwithstanding that it is now accepted that that is the position, they didn't proceed on that basis. Even they appear to have proceeded on the basis that the substantial injustice test is necessary to satisfy. And therefore, I would therefore adopt the reasoning, even if it's on a false basis, that they didn't need to go down that route.
Well, the Supreme Court made no ruling on the point. It was merely an accepted position in front of them, which seemed to tally with the statutory words.
Yes. And of course, the ASM shipping case, which I rely on, was also a Section 68 case. It wasn't purely a bias case. So again, I would suggest that the reasoning in the cases supports my submission. Even if that is a matter that is ruled on by the court. So I don't think in my submission it doesn't detract from my submissions, especially the ASM shipping case, which is a 68, and the same approach is taken. I was, my lord, just going to deal with Bullfrect, because a great deal of weight is put on that case. That is 1930 of the bundle. Under the heading Section 68 of the Act. And where he says, the judge says it's a two-stage process, page 9. The judge says it's for this reason that Section 68 involves a two-stage process. The first stage involves asking whether there's been an irregularity, at least one of the 9 kinds, identified in subsection 2A to 1. The second stage involves asking whether the incidence of such irregularity has caused or will cause substantial injustice. Now, we submit that the judge is simply just setting out the nature of the structure of the Section 68, but the majority of the Court of Appeal relied on that as authority for the proposition that Justice Winder was required to do a separate investigation into substantial injustice. And with respect, that is not what Mr. Justice Coleman said. His analysis merely reflects the language of Section 68, which requires both an irregularity and substantial injustice. And the same structure is contained in Section 35 of the Bahamian Act on Bias. He didn't say they must both be found by separate investigations, or that it wasn't possible to infer this requirement from the nature of the case itself. So we, in our submission, the majority misapplied Mr. Justice Coleman's statement. I'm sorry, Lord Legate.
Does it actually matter, Mr. Flynn, what Mr. Justice Winder should have done? I mean, suppose he should have addressed injustice separately. I mean, does that matter unless he should have found that there wasn't a substantial injustice, in which case his decision was wrong? But one can argue about this in the Court of Appeal, and if it didn't make a difference, then it's the same sort of point that could be taken as is the point being taken about the arbitrator, really.
Yeah. So it's your lordship's point that it doesn't matter unless one can show that there wasn't in fact substantial injustice.
Yes. Yeah.
Agreed. We do keep coming back to the point, which is no one was saying, not only did he not mention it, but in fact, had he mentioned it, he would put his mind to it and realise there wasn't substantial injustice because, for example, the case was a hopeless one. But that didn't happen. Absolutely. And so one is looking at reading the first instance judgment with, in my submission, very unfairly looking for issues, looking for problems that aren't there. I mean, taking a step back, this test is in the statute. If the judge says the statutory test is satisfied, one wouldn't be here. It would be plain that he's put his mind to it. Now, simply because he doesn't repeat the words in the statute, the whole case has been built on that edifice. So I agree, it's rather unrealistic in my submission, but obviously I do need to address the case against me. But it is in my submission.
Putting the point is, if a judge doesn't address the point, then you either decide it yourself on appeal, don't you, or you send it back to him. But you don't say, all right, well, the claim fails altogether because the judge hasn't dealt with it.
Yes, and it goes even further in this case, which is they all agreed there was substantial injustice. That's in paragraph 151. The minority judge records that all three agreed that. And so it's even more extreme, this case, than an ordinary case. It's not as if there was any doubt about the substantial injustice. In fact, they all agreed that there was substantial injustice. It was just it wasn't set out in the first instance judgment. So I'd agree, my lord. Lord Hamlin, you had a...
I was going to refer you to paragraph 151, which does seem to make that very point. That's page 240 of the one.
Yes. Yes. He says, I think, very powerful paragraph amongst a number of powerful paragraphs. Whilst it was perhaps prudent for the judge to have spelt this out in his judgment, I do not think he should be criticised for failing to state the self-obvious proposition. Again, I gratefully adopt that. Further still, I do not think it would be proper exercise of our appellate jurisdiction to set aside his decision when we are ourselves satisfied that on the material, the irregularity, i.e. the failure to consider such an important issue, will cause substantial injustice.
I'm not sure he's saying that the whole court are of that view. I think he's saying that if that is the view, then he shouldn't be setting it aside.
Well, I'm not sure, my lord, because I read it, I have to say, as being a record that they did make that finding. Would not be a proper exercise of our appellate jurisdiction to set aside when we are ourselves satisfied. He can't be referring to just himself. So he must be referring to all three judges, that we are ourselves satisfied on the material, the irregularity will cause substantial injustice. And I think the judge went out of his way to record that fact, that what was really the majority were concerned with was a construction of the first instance judgment in circumstances where it was not only not suggested that there wasn't serious irregularity, but all three members of the Court of Appeal considered that on the facts it will cause substantial injustice. It's just that the first instance judge didn't go through the right motions of having the point pleaded and separately and independently expressly addressed. So I do, with respect, I did read that as a record that all three considered that was the case on the facts. It was just that the judge hadn't dealt with it.
Other than what Sir Michael says at paragraph 151, is there any other indication on which you found in the judgment of the Court of Appeal which supports your view that all three judges were holding or were of the view?
No, my lord, it's only paragraph 151. And if your lordships read it differently, so be it. But it did sort of leap off the page to paragraph 151 comment, which accords with my submission, which is ultimately the appeal is it's all about form over substance in my submission, and that's where we keep coming back to that. Now, my lords, I see that might be time for the break, if that's convenient. I was going to go on to the next point. I'd be guided by the panel, but one thing I did want to do was to take, if the panel would find it useful, was to take you through the documents which show why we say that on a fair reading of the material, substantial injustice was alleged. I will have to take you through the documents for that. I'm happy not to do that if you would prefer me not to. And I clearly need to deal with the paragraph 10 and Kazakhstan decision. I would like to do that. But that was where I was going to next. But if the panel don't want me to do that, I'd be very happy to be guided by the panel as to what approach. Otherwise, I will take you to the documents to show to make my case good.
Yes, I think given the nature of the dispute on this, it would be wise to go through those documents, albeit briefly. Do you want to do that now or after a break?
After the break, my lord, if that would be convenient.
Yes. Well, all that needs to be done to give effect to the break is that you mute your microphone and stop your video for the 5 minutes. But the court will adjourn for this 5-minute adjournment. Thank you. Mr. Flynn, I invite you to resume your submissions.
Thank you, Lord Hodge. So I wanted to turn next to the facts to show briefly that on a fair reading of the key documents, substantial injustice was alleged. We've set out the position in our written case at paragraphs 19 to 21 at pages 1674 to 1675, but we don't need to turn those up. I just want to show you some of the key documents. The first is the notice of motion at page 72, which is the paragraphs 5 to 8. And I just ask your lordships to read those, please. So all of those paragraphs concern the 6-year period for which the arbitrator awarded damages for loss of profits. Paragraph 5 begins alternatively because this is the start of a self-contained sequence. Paragraph 6 complains the award was seriously irregular because damages were given for the 3-year option. Paragraph 7 complains the tribunal didn't deal with 2 issues put to it relating to the period for which damages were awarded. That is, the renewal option had not in fact been exercised, and it was in any event uncertain, illusory and unenforceable. Paragraph 8 begins in the premises, complaining that the award of damages for 6 years was seriously irregular. If you would mind just going over the page, reading paragraph 10, please. That's the paragraph 10 ground.
For the one in paragraph 10, that
Yes.
simply was a separate point made about the lack of documentation, 15%.
I wonder if you could repeat that question, Lord Hamlin. You got your connection was interrupted.
So paragraph 10 appears simply to go to the disaggregation point.
Yes.
There's a separate complaint made about the 15% deduction because of lack of documentation.
Not
So where is it?
Not in this ground, no. I'll just see if there's a separate claim, but not under that ground, no. The 10 point is the failure to deal with the issue as a matter of principle, the disaggregation point. And it's not the subject of the appeal, certainly, I put it that way. The ground they were it's section 10, so it's the failure to disaggregate the losses. I mean, it does say on a basis which was not supported by the evidence. So 1, 2, 3, 5 lines down in paragraph 10, the tribunal itself disaggregated the losses on a basis which was not supported by the evidence, not canvassed with or addressed by the parties, and first mentioned in the award without giving the parties an opportunity to make representations in relation thereto. So the heart of the point in my submission is wrapped up in that paragraph 10, which is because it wasn't supported by the evidence.
A finding that something isn't and a challenge that something isn't supported by the evidence would normally be a legal challenge under section 91. It seems to me that in your case that the heart of the challenge has to be the fact that there was no opportunity given to the parties to address the point either in evidence or in submission.
Yes, your lordship's right. I think it's to be fair that these matters aren't set out with crystal clear clarity, but our point on paragraph 10 is, in essence, that it was a global case with no alternative, and the tribunal should not have proceeded, even if there had been evidence, unless there was an alternative case advanced. It was advanced only as all or nothing, and the tribunal could only deal with it as all or nothing. And it was a serious irregularity to do what the arbitrator did, which was to make a decision which hadn't been advanced by either party, unheralded, and the first time it's seen is in the award. And that we submit as a serious irregularity. So it doesn't turn whether there was or wasn't evidence as a matter of principle. Now, these points were elaborated on in the skeleton. The relevant part of it starts at page 127 of the bundle, but the relevant part is at 151. And I should say, of course, the evidence reflected the fact that it was an all or nothing case. So I think, in a sense, that's the point being made, which is the case was advanced as all or nothing, and the evidence was presented on that basis only. If I could ask you to turn to 151, please, at paragraphs 57 to 60. If I could ask you to read those, I think that would be the quickest way. They elaborate on the 5 to 8 grounds. So my lord, so what you see there is 57 sets out the complaint that the lease hadn't in fact been renewed as no notice had been given. 58 cites the Australian case of Crown Melbourne, which was the authority the appellants had relied on in the arbitration in support of its argument that the renewal option was unenforceable. 59 complained that the arbitrator had never addressed the issue of whether the lease had been renewed, nor did she address the critical issue raised in the applicant's closing submissions to the effect that the renewal clause was in any event unenforceable. And paragraph 60 described these as critical failures and referred to the fact that such a large portion of the award is attributable to this renewal period. And then if I could ask you to go over the page to 152, please, and just read paragraph 61 and 62, which are the paragraph 10 ground. So what you see there is paragraph 61 described the challenge facing the arbitrator, namely how to disaggregate the respondent's loss of profit claim when their claim had been presented on an entirely global basis. And the submission identified the precise submission that the appellants would have made had it been given an opportunity to address the issue, where it says it's obvious that where a business comprises 4 elements, one element may together with the other 3 be profitable in the amount of X dollars, but that doesn't and cannot show that it would as a standalone business have been profitable, either in the amount of X or at all. And then 62 complained the first time the arbitrator's adjustment of the respondent's profit and loss claim was advanced was in the award itself, and that the approach was entirely impressionistic. Now, there's one correction to our written case which I should make. The respondent's primary submission in its skeleton at first instance was that none of the appellant's complaints amounted to an irregularity within the meaning of the Act. And I set out the references at paragraph 20 of my written case. But we say in paragraph 20 that it was no part of the respondent's argument at first instance that the appellant was required to make and had not made an express and separate allegation of substantial injustice. But that puts the point too high. It is true that the respondent didn't argue the point in writing, but on close examination of the transcript before the Court of Appeal, it shows that they did make that argument orally at first instance. And the appellant's answer before for Justice Winder was that the injustice spoke for itself. And I will come back to that in a moment when I take you to what happened before the Court of Appeal. It's at page 1598. But before I do that, I'm sorry, Lord Barris.
I've just got a couple of questions at this point, if I may.
Yeah.
The complaint is that the arbitrator took an entirely impressionistic approach to the figures she had before her. Might it not be said that that is a complaint based on an error of law rather than a procedural error? I mean, don't judges and courts very commonly, in the light of evidence, take an impressionistic discount figure? That's my first point.
Yeah.
The second is, I wonder if you can just help me with the facts in relation to this question of renewal of the lease. So the argument being made is there was no intention expressed of wishing to renew the lease. But I'm slightly puzzled as to what the factual scenario was. I mean, my understanding was the building had been demolished. I mean, what would there be to renew?
Well, my lord, there are two questions. Can I deal with the impressionistic one first? If our case was simply that the arbitrator had got it wrong because they took just an impressionistic view to the evidence, that would not amount to a serious irregularity. The point on paragraph 10 is a different one, and that is if the case before the arbitrator is approached on a global basis and no alternative case is advanced, it is not open to the arbitrator to proceed on an alternative basis without giving the parties a proper opportunity to address an alternative case. That's essentially it. It's not based simply on it being impressionistic. I think the minority in the Court of Appeal did refer to the impressionistic approach to damages and the fact that it seemed very large in relation to the liquidated damages provision in the lease of $7,500. But that's not our case. If you're against me on the issue of principle, I couldn't support my case simply on the basis that the arbitrator took an impressionistic approach. The impressionistic approach is a consequence of the failure to approach the matter on a principled basis. So the arbitrator should not have done what she did, which is seek to award damages on a basis not advanced by either party, at least not without giving them a proper opportunity to do so. On the renewal of the lease point, you're right, they had been evicted and there had been no, in fact, renewal, but damages were awarded on the basis that there would have been an exercise of the option and a renewal. And the point taken by my clients was, you can't make that assumption because we have a substantial case based on Crown Melbourne, and we wish to make submissions and do make submissions on the basis that it could not have been renewed. In other words, that damages had to be limited to 3 years and not 6. And the complaint there is that the arbitrator didn't deal with that issue. She didn't address it. So it's that the argument wasn't dealt with. It wasn't in fact exercised because the property was demolished before the time for exercise. But the arbitrator proceeded on the assumption that it would be 6 years, and that included an assumption that the extension would be effective and exercised. And the point was that that was an issue, and it was an issue that wasn't addressed.
Well, I can see the point you're making about whether or not the clause was enforceable, that is the renewal option. I'm just querying how realistic it is to imagine that there's some flaw by not thinking about whether there was any indication given of wishing to renew in a circumstance where that would seem on the face of it, unless I'm misunderstanding the facts, to be rather unrealistic.
Yes, I mean, it's not so much about the indication of renewal, it's whether or not, in fact, it could, as a matter of law, have been exercised. Our case was, you can only award damages for 3 years because the lease wasn't capable of renewal based on Crown Melbourne, if one looks at the terms of it. Now, I should say that, I mean, I hesitate to say what is and isn't advanced in this case, but I don't understand it to be advanced against me that there's anything wrong in principle with the submission that the option couldn't be exercised. What is said against me is it's not an irregularity and there's no substantial injustice and so on. But that is a matter for argument that simply wasn't addressed by the arbitrator. And that is a matter that would have to, or if we win.
I understand that, but in the way you've just expressed it back to me, it sounds as if you are really pinning this point on the enforceability or non-enforceability of the renewal option, not on whether no notice had been given by the respondent of an intention to renew the lease.
Well, I in a sense, I suppose that is fair, in that I'm not sure the time for the exercise of the option had arisen, if I'm right. So your lordship's right. That may not be the most significant submission. But in a sense, in what I would say, it doesn't matter in this sense, which is that it's plainly an important issue, and it's plainly one on which full submissions should be made, in my submission, to the arbitrator. If we succeed in this appeal, it's a matter that will need to go back to the arbitrator for the arbitrator to decide in the light of all the submissions on the point. And it may be at that stage that there's not much weight is attached to whether, in fact, there was any intention given as to the exercise of the option. The real question is on Crown Melbourne is whether or not, in fact, it could be exercised. The point being that the arbitrator just assumed this point. It was an issue that we submit should have been decided by her and wasn't. It was just simply ignored. And the arbitrator just proceeded on the basis as if it wasn't an issue. I'm sorry, yes, Lord Stevens.
Well, I'm just a little bit uncertain as to where that leaves one with ground 7 at page 72, because Roman numeral 1 is the point that my Lord Burrows was addressing, and I think you said that it was fair at one stage, and then you said it was not the most significant submission. But what is the issue? Is it really being contended that the arbitrator should now determine whether or not the lease had expired because no notice had been given in circumstances whereas here somebody had taken a bulldozer to the premises?
Well, my lord, I would look at it in a broader way, which is if it went back to the arbitrator, the issue before the arbitrator is in essence whether or not the lease could have been renewed and should have been renewed, and to be assumed that it was renewed. Now that will be a matter of submissions at that stage. Your lordships don't have the full picture on this. In my submission, provided I can satisfy the tribunal that it was an issue and that it wasn't dealt with and that it is a critical issue, in my submission it plainly is a critical issue because it's 3 years of damages, then that is, and it wasn't dealt with and should have been, then it is a matter that needs to go back to the arbitrator to determine. The complaint here is that it hasn't been determined and should have been, and the arbitrator simply operated on the assumption that it had been and didn't address it at all. And that, in my submission, is not a matter that your lordships, it's not said against me, this is a hopeless argument. As we've already covered, it's not suggested that there's no substantial injustice because the case is a bad one. It's simply that the judge didn't say so in terms. So that, in my submission, is all a matter for subsequent argument or remission as to the nature of that case. But the fact is, it wasn't dealt with by the arbitrator, and that's the nub of the complaint. And it can't, in my submission, realistically, and isn't, as I understand it, said against me that the claim is so hopeless there's no reasonable prospect of it succeeding. And that would only it would only be if that were the case against me that would arise. If your lordships are with me that it was an issue put to the tribunal, ought to have been dealt with and wasn't, in my submission, that's a serious irregularity, substantial injustice, and it needs to go back to be argued. So that's really the essence of it. It's not the nature of the case itself. It's the fact that it wasn't dealt with. In other words, it's not about whether the arbitrator was wrong. It's the fact that there's been a procedural irregularity in failing to deal with that issue. I hope that answered the question. Of course, you would have had far more submissions on the point if it had ever been suggested that this didn't meet the test of substantial injustice because it was a hopeless point. It's not been said. It's really just a matter of procedure rather than substance. And we submit it's not even said against me that if we're right and we establish all of those points, that it's not reasonably arguable claim. I'm sorry, my lords. I was just on. Then if unless there are any other questions, I was going to go to Miss Justice Winder's judgment next. That's and that is page 15. It starts at page 157. I'd like to go to 163, please. And this is where he deals with his analysis. And I wonder if we could go through these paragraphs together, starting at paragraph 18. It's under grounds 5 to 8. This is where he deals with. This is where he deals with the complaint. You'll see the applicants made various complaints surrounding the determination of the arbitrator to make an award outside of the 3-year term of the lease. The various grounds are the tribunal exceeded its powers in awarding general damages for consequential loss, for breach of contract, trespass and unlawful interference for a 6-year period. The lease was for a term of 3 years. The demolition took place on the 18th of July 2013, and therefore the award was irregular in that damages for the alleged tortious acts of the claimants were backdated by the tribunal to run from the commencement of the lease and were a 3-year option year. The tribunal did not deal with the issue put to it, namely the term of the lease expired on the 30th of December 2014, and the option clause was uncertain, illusory and unenforceable, as it required the parties to agree the rents to apply to the renewal term. The tribunal was empowered to award damages for a period being the remainder of the lease from the 18th of July 2013 to the 30th of December 2014. The tribunal had no power to award tortious damages for the period prior to the demolition or after the expiry of the term of the lease. And then if we go on to paragraph 20, the applicants also say that the arbitrator never addressed the issue of whether the lease had been renewed, nor did she address the critical issue raised in the applicant's closing submissions to the effect that the renewal clause was in any event unenforceable, it being uncertain and illusory in accordance with the above stated principles. And then the importance of the point, the issue is seen in the Supreme Court Victoria case of Crown Melbourne, and then cites that. And then at 22, a review of the award doesn't reflect the fact that the arbitrator considered the issue of whether therapy would be entitled to damages during the renewal period. It seems to have proceeded on the basis that therapy was entitled to these damages. Whilst not every argument of counsel demands consideration by the tribunal, this was an issue which turned out to be a central one. It was first raised by therapy in paragraph 70 of the statement of claim, and the said issue was joined by the applicants in their defences. The issue was also traversed in closing submissions. And then he sets out at paragraph 23, section 90 in full, and at 24, he says the applicants were entitled to the consideration of the tribunal on this issue. And insofar as it was not provided, I find there was a serious irregularity, and that part of the award ought to be set aside and remitted under section 92D. If we go on to 168, this is where he deals with the paragraph 10 point. And if you look at that, and then he deals with that from paragraphs 28 onwards. At paragraph 28, he sets out the nature of the complaint and sets out the paragraph 10 of the notice of motion. Paragraph 29, he says therapy in its pleaded claims alleged that it commenced operations at the Sakura Beach and restaurant premises on the 31st December 2011 and continued in operation until the 18th of July 2013, although by reason of the respondent's breach of contract, it did so from a partially completed and deficient building. And then he goes on, if we go on to 33, that's where he says, the applicants argue the arbitrator adopted an entirely impressionistic deduction to arrive at a loss figure without giving the parties an opportunity to make submissions in relation to it or lead evidence in relation to it. Now, I'll just pause there. I do agree that the heart of it is not the impressionistic deduction. It wouldn't, in my submission, it wouldn't matter if the deduction was very well founded and well reasoned. The complaint is that it was done at all in the circumstances to support a case that hadn't been advanced by either party. But it's obvious that throughout this, there has been a complaint that it appears entirely impressionistic, but the heart of my complaint on this appeal is that it's an exercise that shouldn't have been done at all. Then at 34 to 35, the judge refers to section 44 and 90 of the Act and refers to case law in Wetherspoon. And then at 36, he records the submission that the appellant said it would have made had it been given the chance to do so. And then at 37 and 38, at page 173, he accepted the appellant's arguments and held that the arbitrator's assessment had been impressionistic and that the appellants, more importantly, were not afforded an opportunity to make representations prior to her decisions to make adjustments. So we submit that Justice Winder accepted the appellant's complaints on both the paragraphs 5 to 8 grounds and the paragraph 10 ground. And that is also recorded at paragraph 50 at 177. If you go to 177, he says, in all the circumstances, I find there was a serious irregularity in the determination of the award of general damages, and the award doesn't reflect that the arbitrator considered the issue of whether therapy could claim losses occurring not only in the remaining term of the Sakura lease, but also in the renewal period. And then the decision of the arbitrator was unfair and contrary to section 44 of the Act. in that the applicants were not afforded an opportunity to make representations prior to her decision to make deductions and allowances for the removal of sums attributable to claims which she had disallowed, and the inaccurate recall of the respondent's own expert witness. And that, as a result of that, he made the remittance orders that I showed you earlier. And in our submission, the learned judge was right to do so. Then if I could go next to the Court of Appeal decision, and the majority first of all, I set all of this out in my written case at paragraphs 28 to 33. But if we could go to page 196 first of all, please. And this is the leading judgment of Sir Hartman Longley. And if we could pick it up, the judgment, actually it starts at 106, but if we could pick it up at page 204, I'll just show your lordships what happened there. I'm sure you've already read it, but just at paragraph 14, he summarised the respondent's case and made 2 points. Firstly, that Justice Winder lacked jurisdiction to make the remittance order, and that the requirements of section 90 were not satisfied. Now, the jurisdiction point failed, and so we could ignore it. But then at 16 to 25, he refers to section 90, and he refers to some English cases. The key passage is at paragraph 26 at page 208. And then he says, the respondents in essence argue it's not a question of jurisdiction at all. I agree. However, that seems to be more a question of semantics. Sometimes the words are used interchangeably to mean power. It is clear the judge had the jurisdiction to make the order and finding of irregularity. The jurisdiction comes from the award itself. At 32, he refers to transition feeds, and that sets out this test for substantial injustice, but it doesn't say how it would be satisfied. And then at 33 to 35, then refers to the decision of Mr. Justice Coleman in Bullfract, which I've taken you to. And he concludes that that case required Justice Winder to do a separate investigation into substantial injustice. Now, I've already explained why we submit that that was wrong. And then at 36 to 41, the judge holds that the appellants were under an obligation to plead a separate allegation of substantial injustice and to support that allegation with evidence, which it hadn't done. And then over the page, at 44 to 48, he makes a similar point. And then at paragraph 71, page 222, he criticises the judge for not separately considering substantial injustice. So in my submission, it's clear when one reads this judgment, the majority's decision rested on the conclusion that the appellants were required separately and expressly to allege substantial injustice, and that Justice Winder was required to give it separate consideration and make a separate and express finding to that effect. And we submit that approach is wrong in law. And I think I'm running out of time, but so I just want to show you two passages in the, in fact, one paragraph of the minority judgment. You've already seen 151, which I rely on, but if we could also look at 147 at page 239. What Sir Michael Barnett says there, in this case, it is, in my view, unarguable that the failure to consider whether the renewal option was efficacious must lead to substantial injustice. And it's very important that the focus is on the failure to consider, not on the arguments. It's simply that the arguments weren't addressed. If the option wasn't efficacious, then any award which took into account lost profits during the 3-year renewal period would cause substantial injustice. The injustice caused by the failure to consider that issue is self-obvious, and no evidence would, in my judgment, be required. And in my submission, absolutely right about that. Particularly in a case like this, one doesn't need evidence to establish that. It's really, in practical terms, it's for the other party if they're saying that there is no substantial injustice, to advance their case to show why it's a hopeless case or it's not reasonably arguable or so on. And so in my submission, 147 and 151 are absolutely, I adopt those as my submissions. They're absolutely right in principle in my submission. Now, I'm going to skip over some of my submission because I do want to get on to Kazakhstan. Yes, I'll very briefly address one issue, which is the failure to deal with an issue put to the arbitrator. I've set it out in some detail in my case at paragraphs 83 to 92, and I'm not going to take you through that now, not simply because of time, but I don't understand much of it to be disputed, but I just wanted to highlight 3 points. Although the arbitrator's award didn't have to address every point or submission made by the parties, it did have to deal with all those issues which were essential or fundamental to the decision. And the renewal period was. The authorities for that are set out in paragraph 85 of my written case, and I believe they're common ground, but if they're not capable of serious dispute. I'd also ask the panel to note the decision of petrochemical industries, which I deal with in paragraphs 86 to 87 of my written case. In that case, Mr. Justice Andrew Smith rejected the submission that an issue had to be something which would be included in a list of issues, and that it didn't include, for example, sub-issues. Certainly didn't require the matter to be pleaded, even in a court context, let alone an arbitration. What mattered was, I'm quoting Mr. Justice Andrew Smith, fairness demanded that the question be dealt with and not ignored or overlooked. And we submit that is right. And in this case, in my submission, it's absolutely plain that fairness demands that the renewal period was a question that had to be dealt with and couldn't properly have been ignored or overlooked. There's one other thing, I don't have time to deal with it now, but that it is this. One of the issues against me is it is said that the issues weren't put to the tribunal. Now, I've dealt with that at some length in the written case. And what matters for present purposes are the appellant's oral closing. And I'll just give you the reference to those. They're at pages 1544 to 1548 and 1571 to 1572. If you read those passages of the transcript from the final day of the arbitration, it is absolutely plain that the issues as to the exercise and enforceability of the renewal option were clearly advanced to the arbitrator. And the arbitrator confirmed her understanding of the appellant's case with a number of questions. And it was never suggested by the arbitrator that, or anyone else, that those points weren't open to the appellants. It does require reading that transcript, but it's absolutely plain that the issues were before the arbitrator and understood to be so. Finally, yes, so I just want to deal with the paragraph 10 ground, particularly because of Lord Stephen's points and a number of the other members of the panel. Very little is said by the respondent in their case on the paragraph 10 ground. And the key authorities we set out at paragraphs 93 to 101 of our written case. I only want to show you two. The first is Zermatt Holdings, which is at page 2541. It's a judgment, it's a very well-known judgment of Mr. Justice Bingham, as he then was. It's an old case, but the second to last paragraph on the page, beginning nevertheless. So page 2541, it's about 4 lines down. And Mr. Justice Bingham says, nevertheless, the rules of natural justice do require that matters which are likely to form the subject of decision, insofar as they are specific matters, should be exposed for the comments and submissions of the parties. If an arbitrator is impressed by a point that has never been raised by either side, then it's his duty to put it to them so that they have an opportunity to comment. If he feels that the proper approach is one that has not been explored or advanced in evidence or submission, then again it is his duty to give the parties a chance to comment. It is not right that a decision should be based on specific matters which the parties have never had the chance to deal with, nor is it right that a party should first learn of adverse points in the decision against him. And then I'd like to show you the decision in Kazakhstan and Worldwide Minerals, starting at page 2360. And you'll see from it's a decision of His Honour Judge Pelling in the Commercial Court, recently given in November of last year. And we don't rely on that case as establishing any new principle of law, but it is an example of how the law should apply in our submission on very closely analogous facts. What happened was Worldwide brought a claim against Kazakhstan alleging various breaches of a bilateral investment treaty. And it said that taken together, Kazakhstan's breaches amounted to an expropriation of its investment, and it quantified its claim on that basis. The short point is that the damages claim in the arbitration was advanced on a global basis, with no attempt to break down quantum by reference to specific or individual breaches, and certainly not by reference to the limited breaches found by the tribunal. No alternative case was advanced. And I'll just show you a few passages. If you go first to page 2365, please. And you'll see paragraphs. Could I ask just the panel if they would read just paragraphs 10 to 13, please? Because that sets out the background to the case and the breaches. So what you will see from that is that Worldwide advanced a number of claims, but only 2 of them succeeded. The tribunal held that Worldwide's investment hadn't been appropriated. And you'll see from paragraph 3, there was no attempt to identify what losses were caused by each of the breaches as they were found by the tribunal. If you go on to 2367, please, at paragraph 18. What you'll see is, thus, the tribunal appears to have approached what it had concluded amounted to the loss of a chance or opportunity on the basis it entitled the defendants to recover the whole of its investment, being the sunk cost. That resulted in an award of $3.7 million, calculated in the manner set out in paragraph 596 of the award, together with interest and costs. It did so, notwithstanding that is not what had been argued for by the defendants, and ignored what its own counsel had said concerning the approach to be adopted in the event that the tribunal concluded that some but not all of the breaches alleged had been proved, as explained below. It is this paragraph of the award that TRK focuses on. And then if you look at paragraphs 19 to 21, what you'll see there is that Kazakhstan challenged the award. It had argued the tribunal should make a partial award on liability and invite further submissions on quantum in respect of such breaches as the tribunal found to be established. And it also said that if some but not all of the breaches were upheld, Worldwide's claim should fail because it had premised its entire case on proving all of the breaches alleged. In other words, it was similar to this case, it was an all or nothing case. And one party was saying, well, if you don't prove everything, you get nothing. Now, His Honour Judge Pelling accepted those arguments, and the submissions in response were, as Lord Stevens put to me, that in fact you did have an opportunity to put in whatever submissions you want, but they didn't find favour with the judge. And if you go on to 2373, please, paragraphs 31 to 33, page 2373. Where he says, in my judgment, TRK is entitled to succeed on this issue. My reasons for the conclusion as follows. TRK had submitted that in the event that some but not all breaches alleged were proved, then the claim should fail because no alternative case had been advanced by WWM on the basis that it succeeded on some but not all the breaches alleged, and had submitted only that it should recover damages on one of three bases identified by the tribunal in the event that it succeeded. WWM had submitted that if some but not all breaches were proved, then the tribunal should make a partial award on liability and come back to the parties on damages for the part of that the tribunal finds liability on. This submission reflects almost exactly the approach that Popplewell has held should be adopted. Now, we submit that should be followed in this case if the arbitrator considered that there had been a case on liability not advanced by either party. There should have been a partial award with an opportunity for the parties to address the alternative case. The tribunal didn't adopt either the course of rejecting WWM's damages claims on the basis contended for by TRK, or acceding to the course contended for by WWM, but instead concluded at paragraph 587 of the award that the failure to grant a licence clearly contributed to the demise of the investment. The respondent's subsequent failure to assure that the claimants learned of the bankruptcy proceedings denied the opportunity to seek to protect their claim security interests in TGK's assets, and the resulting damage suffered by the claimants would be appropriately compensated by the recovery of their sunk costs. In my judgment, the tribunal should have adopted the course suggested by counsel for WWM at the hearing before them, and by failing to do so, deprived TRK of addressing what losses had been caused by the breaches found proved, an issue that might have required additional or updating evidence on quantum and submissions. The approach adopted by WWM's counsel referred to above was the appropriate one in the circumstances for the following reasons, and then he sets out his reasoning. And then if you go on, please, to the conclusions at 2377, paragraph 48 at the bottom of the page, he summarises his conclusion. In summary, there were only two fair alternatives open to the tribunal in light of its conclusions concerning breach, given the way the damages claim had been advanced by the defendants at the hearing and in prior written procedure. And that was either to accede to TRK's submissions that the defendant's damages claim should fail, applying a particular case, or two, should fail, or B, to publish an interim award setting out the tribunal's breach and findings and inviting further submissions concerning the quantification of damages in the light of those findings. What it could not do without breaching section 33 of the Act was to proceed to assess damages in the manner set out in paragraph 587 of the award, without having published an award setting out its findings in relation to the breach issues and giving both parties the opportunity to adduce evidence and or advance submissions to what damages could be held recoverable for those breaches found proved. This was so because the award of damages for loss alleged to have been caused by particular breaches were not in play, or sometimes it's in the arena. And that is his conclusion. And then he says at 49, by proceeding as it did, the tribunal decided the case on the basis of a point that TRK had not had a fair opportunity to deal with. That it submitted the damage claim should fail in the event that only some of the alleged breaches were made good is not to the point, because the only basis on which WWM had argued the claim was the global all or nothing basis referred to above. There was no alternative claim for damages caused by each individual breach relied on, and so nothing in respect of which alternative submissions could be made. It is not for a defendant to set up or attempt to answer an alternative claim in damages that is not being advanced by the claimant. And my lord, I hope that that helps address Lord Stevens's point, which is, it may be said, oh, well, you can always guess that there might be a case, possibly. But what is being said, what was said in this case, is it's not up to a party to set up or answer a case that hasn't been advanced. So in our submission, so far as the paragraph 10 case is concerned, we submit that Kazakhstan is on all fours with the current case. The claimant presented one global claim for damages. There was no alternative case advanced at all, certainly no alternative case on the basis of the breaches found by the arbitrator. So the damages that the arbitrator found were not in play or in the arena, and therefore there was no proper or fair opportunity to advance submissions on the basis of the breaches actually found. So we rely on the decision, in this case, applying well-established principles to show that our paragraph 10 case is a proper serious irregularity case, because there wasn't, in the circumstances of this case, a fair opportunity to deal with the damages claim that the arbitrator in fact found. I see that I have 2 minutes, and I was, I think, that's probably.
Mr. Flynn, if you can, of course, eat into your reply time if you so desire.
Yes, well, that's very kind, my lord. I don't think so, my lord. I think I would like to save some time in reply in case there is anything that I do need to deal with. I hope, yes, Lord Hamlin, I hope that that has addressed the paragraph 10 issue in principle, though, as to how we advance that as a serious irregularity. Sorry, Lord Hamlin.
So do these arguments apply to the 15% discount because of lack of documents or recollection, which seems to be a rather different point, perhaps closer to Lord Burroughs' impressionistic approach point?
Yes, it's not. It's the point is that insofar as quantum was found in relation to the alternative case, on remission in my submission, that is all up for grabs. It's not because the arbitrator's approach was one which was impressionistic or irrational or anything of that kind. If you're with me on the point of principle, it is that the arbitrator should not have undertaken this exercise at all. And as a result, what the arbitrator should have done is either before making any award or giving a partial award indicating the liability findings or intended liability findings, is then to address in the light of submissions and evidence what the quantum should have been. So in other words, even if the arbitrator, I don't accept it's relevant or indeed really material whether the exercise was a good one, a bad one, or an indifferent one on the basis of what was before the arbitrator. The point is that it's an exercise that shouldn't have been done at all. So in other words, even if the arbitrator applied a perfectly appropriate, rational approach, as happened in Kazakhstan, it wasn't that no one was saying that the eminent tribunal had behaved impressionistically or otherwise in awarding sunk costs. What the judge in that case said was that award shouldn't have been made on any basis because it shouldn't have been done without giving both parties a proper opportunity to address the issue, put in such evidence and submissions as they wished on that issue. So if your lordships are with me on the issue of principle, this point gets remitted back to the arbitrator to consider in the light of the findings of liability, but in the light of further evidence on the issue of quantum and what the proper approach is. So it's not founded upon the exercise that was in fact undertaken by the arbitrator, good, bad, or indifferent.
Well, Mr. Flynn, we will, of course, treat everything that you've said in your written case as part of your case. Do you wish to complete your submissions at this point?
I do, my lord. I'm very anxious that I know that one of the key issues that the panel are concerned about is this paragraph 10 issue and the approach. I hope Kazakhstan sets out why we say it's a matter of principle in this case. I accept that it's not a question here of not taking the opportunity to make as fulsome and as full submissions as one would like. That would not, I accept, be a serious irregularity in itself. The difference here is that the case advanced before the arbitrator was all or nothing. It wasn't open to the arbitrator to approach it on a different basis, not least without giving the parties a fair opportunity to address an alternative case. What was objectionable was putting it in the award, and the first time it was seen was in the award. So it's not my case that in general it's a serious irregularity not to take up an opportunity that's given. This falls foul of the line as a matter of principle. And I just want to make that very clear. We're not seeking to move the boundaries on what is appropriate in terms of what a party can or should do when it's given an opportunity to make submissions in the ordinary course of things. So, my Lord, unless the panel have any questions, those are my submissions.
Thank you very much, Mr. Flynn. Ms. Rowe.
Good morning again, my lords. On the primary issue, my lords, that being whether or not on the hearing of a challenge under Section 90 of the Arbitration Act, the court is required to consider separately the issue of substantial injustice and to make a determination on that issue. The respondents say absolutely, unequivocally, yes. The reason why we say this, my lords, is because this is what all, not some, all of the authorities demonstrate in our respectful submission. Now, my lord, you may note that as between the appellants and the respondents, in the joint bundle of authorities, there are 39 authorities cited as between the appellants and the respondents. And we say that in each of those authorities, you see the process where the court on hearing, under the UK Act of Section 88 challenge, Section 68 challenge, sorry, you see the court recognizing the obligation to determine firstly, whether there's an irregularity under one of the subparagraphs, and secondly, whether such irregularity so found has caused substantial injustice. I think it is quite material that when you look at the manner in which these 39 authorities have been disposed of, I think of the 39, 3 or 4 of those challenges were successful. And in the vast majority, even where there had been no finding of a serious irregularity, the court still went on to consider the issue of substantial injustice in full recognition of its obligation to independently and separately consider that issue. Now, what I should endeavor to do, my lords, prior to the lunch break, is to take you through some, not all of the authorities. Time won't permit me to take you to all 39, but certainly what I shall do is take you to 9 of them, just to establish that first point, that being that there is indeed an obligation on the applicant to a challenge to demonstrate independently that there's been a serious irregularity, and separately that such serious irregularity has caused substantial injustice. And I do believe I can do that first point before we break for lunch or breakfast in my case. So the first of those authorities would be at page 2222. It's the Primera Maritime case. And I'm going to refer, the case starts at 2222, but we're going to go to 2225. And this was a challenge under Section 68(2)(d). And at paragraph 6, and we'll read it together, the court says, in order to succeed under Section 68, an applicant needs to show 3 things. First of all, a serious irregularity. Secondly, a serious irregularity which falls within the closed list of categories in Section 68(2). Thirdly, that one or more of the irregularities identified caused or will cause the party substantial injustice. I'll stop there and go on to paragraph 7. In cases under Section 68(2)(d), that is, of course, failing to deal with an issue, there are 4 questions for the court. 1, whether the relevant point or argument was an issue within the meaning of the subsection. 2, if so, whether the issue was put to the tribunal. 3, if so, whether the tribunal failed to deal with it. And 4, if so, whether the failure has caused substantial injustice. And if we can then continue to page 2238, at the top of the page, paragraph A, I'll pick up at the second sentence, which starts, it follows. It follows that even if there were anything in the point, that is the serious irregularity point, the applicant would be bound to fail because the claimants cannot demonstrate that it would make any difference to the overall decision of the tribunal, and therefore cannot show that any serious irregularity has caused or will cause substantial injustice. So if we can move to the next case, which is then at page 2360. And this is the case that we just ended with my learned friend, the Kazakhstan case. And if we may go, my lords, to page 2371, paragraph 23. And one of the things we see in the authorities is that in each case, almost again without exception, the court, in setting out the relevant legal principles, sets out the principles which are now accepted as being, if I may use the word, entrenched. And the court did that in the Kazakhstan case as well. At paragraph 23, we see the court saying, the principles applicable to challenges under the Arbitration Act, Section 68, were summarized by Justice Popwell, as he then was, in Turner Bahrain Holding Company, WWL, and Al-Shamai. Now, if we go over to page 2371, we see the acceptance of the principle at paragraph 6. The requirement of substantial injustice is additional to that of serious irregularity, and the applicant must establish both. More importantly, if we go over to page 2378, we see that in this case, the court is actually setting out the issues that it is required to consider. Paragraphs 28 and 29, and the court states, as will be apparent from the principles summarized above, and as is common ground, the issues between the parties are as follows. A, whether there has been a serious irregularity within the meaning of the Act, Section 68.2, and if there has been, has it caused substantial injustice to TRK? This depends on whether TRK has proved that had it had an opportunity to address the point, the tribunal might well have reached a different view and produced a significantly different result. Now, let's look at paragraph 29. If each of these issues is resolved in favor of TRK, then it will be necessary to decide whether to remit or set aside the relevant parts of the award. If we can then pick up at page 2378, paragraph 50, you see the issue of substantial injustice being dealt with by the court then under that subcaption. And at paragraph 50, it says, TRK must show that had it had the opportunity of addressing the assessment of damages caused by each of the breaches found proved, the tribunal might well have reached a different conclusion from that which it reached in paragraph 587 of the award, and so produced a significantly different outcome. This issue can be taken rather more shortly than that concerning serious irregularity. Clearly, it's a different issue. In my judgment, TRK has satisfied this test. My reasons for reaching that conclusion are set out below. And you see in the subsequent paragraphs, the court then goes into actually considering and analyzing why it has found that the substantial injustice requirement has been met. So at page 2378, ultimately at the final paragraph, the final sentence of paragraph 55, we see the court saying, these were issues that TRK did not have an opportunity to advance arguments about for the reasons set out earlier. I am satisfied that had it had such an opportunity, the tribunal might well have reached a different conclusion and produced a significantly different result. So again, you see the court analyzing the circumstances which have been put forth as satisfying the substantial injustice test and making a determination as to whether or not the test has been satisfied. Similarly, we can move on to the very next case, which is the Torch Offshore LLC case, page 2382. And we are going to go to page 2398, paragraph 51. At this paragraph, the court says, whichever view is right, in these circumstances, there can be no serious irregularity within the meaning of section 68(2) of the Act, since no substantial injustice is caused to Torch by the award and reasons. And I'm going to stop there. You see the connection being made between the serious irregularity and the substantial injustice, insofar as the court is of the view, this is an expression that we see in a number of the authorities, the court is of the view that serious irregularity in the sense contemplated by the Act is not satisfied unless the substantial injustice requirement has also been met. And I don't think that that position is opposed by my learned friend. However, in disposing of the challenge, the court can only get to that conclusion if it actually considers whether it uses the word substantial injustice or not. If it actually considers and applies the test as to whether or not, had the irregularity not occurred, that irregularity having been found, whether the result may have been different. And you see that in this particular paragraph, in the Torch case, the court is actually saying that unless that substantial injustice requirement has been satisfied, there can be no intervention. And that is the point that I'm going to come back to, because we feel that it is a significant point. But I just want to continue through the process of, again, demonstrating the consistency of approach in all of the authorities, not just the authorities that have been cited by the appellants, but also the authorities that have been cited by the respondents. So if we go to 1940, page 1940, and we're going to go, this is the Kamlika Shipping, Trading and Industry Companies case. We're going to go to page 1944, paragraph 47. And this is a case where the challenge had failed because no serious irregularity had been found. And so now the court is moving on to consider the issue of substantial injustice. And at paragraph 47, you see the court saying, returning to issue number 6, it should already be apparent from what I have said that I consider the fact that it was not dealt with has not caused and will not cause substantial injustice to the owners. I have well in my mind that in determining whether there has been substantial injustice, it is sufficient for it to be shown that if the issue had been dealt with, the tribunal might well have reached a different result. The tribunal may well have reached a result. My apologies, I'll start that sentence over. I have well in my mind that in determining whether there has been substantial injustice, it is sufficient for it to be shown that if the issue had been dealt with, the tribunal might well have reached a different result in favor of the applicant. And if we go to page 1945, which is the page, well, actually we start at the bottom of 1944, that final sentence. I have no hesitation in deciding that even if there was an irregularity in relation to issue number 6, it was not a serious irregularity within the meaning of section 68(2) of the Arbitration Act 1996. So again, you see in this particular instance, no irregularity having been found, the court nevertheless went on to consider the issue of substantial injustice. And again, quite significantly, indicating that serious irregularity under the section is not met unless there is the substantial injustice requirement. So again, you see the separate analysis, the separate treatment of this independent issue. So if we go to yet another authority at page 2022, and this is the authority of Gracie and another and Rose, we're going to go to page 2025. And I should, as context, indicate that, again, this is one of the authorities where the challenge was dismissed. It was a section 68(2)(d) failure to deal with an issue challenge. So at paragraph 20, the court is saying, on any application under section 68, it is not enough for the applicant to make out one or more of the grounds identified in section 68(2)(a) to I if the award is to be remitted to the tribunal or set aside or declared ineffective in whole or in part. Importantly, the relevant irregularity must be a serious one in that it has caused or will cause substantial injustice to the applicant. The parties were agreed that on an application under section 68(2)(d), the test for determining whether there has been substantial injustice requires the applicant to show that if the issue had been dealt with, the result might well have been different. The applicant need not show that the result would have been different. Again, separate analysis, even though you recognize that there had been no finding of serious irregularity. The next case is the one that follows immediately thereafter at page 2039. And this is Grindrod Shipping Pte. Limited and Hyundai Merchant Marine Company Limited. So the case starts at 2039 and we are going to go to 2045. And as we'd seen in a number of the previous authorities, again, the court setting out what is accepted as the relevant legal principles. Number 6 always being the same, that the requirement of substantial injustice is additional to that of serious irregularity. The applicant must establish both. And, our respectful submission is that, that reference to the applicant being required to establish both is setting up a burden on the applicant who is putting forth this application. You have to establish the irregularity and you have to establish, as the applicant, the substantial injustice. Paragraph 7, again, sets out the test. I don't need to read that again because the test really doesn't change. But if we go to page 2051, again, under the caption substantial injustice, you could see the court now going into the analysis. And at paragraph 88, you see, as noted above, the requirement of substantial injustice is additional to that of serious irregularity. And in order to make out a case for the court's intervention under section 68(2)(a), the applicant must establish both. And I'm not going to take you, my lords, through paragraphs 89 onwards, because what's happening there is the court is now, there's an analysis, there's a consideration as to whether or not the substantial injustice requirement has been met, so as to allow the court to intervene. And in this case, the court made a determination that it had not been met. So I think that's probably 6 that I've taken the board to thus far. There's another at page 2193. And this is the authority of Orascom TMT Investments and Vion Limited. And again, this was a challenge under section 68(2)(d). And the challenge was again dismissed on the basis that there was no serious irregularity and no substantial injustice demonstrated. So if we can go to page 2200, paragraph 42. Again, we see under the caption substantial injustice described as step 4. It's step 4 in the process of steps that the court is pursuing in the determination of the challenge. Generally, it's the final step. And you expect to see it, you see it in all of the cases. And the court says, if the claim had survived thus far, what I have considered that the irregularity I would then have found has caused or will cause substantial injustice to Orascom, in my judgment, the short answer is no. And I'll stop there for present purposes. Again, even though the court determined that there was no irregularity, recognizing and being cognizant of the obligation to consider separately and independently the substantial injustice requirement, the court nevertheless, even in the absence of the serious irregularity finding, went on to consider the issue of substantial injustice, almost as a hypothetical, if it were, had they made a finding of serious irregularity.
you've covered 7 of your 9 cases before the short adjournment.
Yes.
But we're now at the time, which is a good rate of coverage. We're now at the time of the short adjournment.
Yes,
the
my lord.
court will adjourn now and resume again at 3 o'clock.
I'm obliged, my lord.
Thank you very much.